Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Judge Richardson.
All right. As you may see, I am working remotely today. I've got people working on my house, and I have my own noisemaker in the background. I have a little dog, so I apologize in advance if he sees a squirrel or something and starts howling and barking madly. Hopefully not. And I've got him in a separate room, so hopefully it won't be too distracting. We are live on YouTube since I'm not able to open the courtroom today. And I think we have all the necessary parties. Mr. Frankel, Ms. Wade are here, Mr. Cloud. Anyone else that we're looking to attend our hearing today?
No, Your Honor.
No, Your Honor.
All right, Mr. Frankel. Well, this is your motion, so I'll let you go ahead and get started.
Actually, I think it's Ms. Wade's motion.
Yes.
Is it Ms. Wade's motion?
It is, Your Honor.
We often get confused for each other. It's the hair.
We have moved to add Ms. Lynn Eden in her individual capacity as a party.
Okay.
Usually it's Mr. Frankel's motion, but this time so I will go ahead and jump in. And I'm not going to rehash a lot of ground. I know Your Honor has spent a lot of time with the parties on the various issues, so I'm just going to jump into the issue at hand. But if I need to backtrack any, I certainly can. I just don't want to waste the court's time or opposing counsel. The issue that is at the heart of this motion is whether to add Lynn Eden, who is the trustee and who is currently a party to this action in her capacity as trustee, whether to add her individually. And under Georgia law, a party acting in different capacities is a different legal entity. So she can be added to this party as an individual, and that hasn't been disputed, and I don't think there is any dispute about that issue. The question is whether this court's going to exercise its discretion under the Georgia statutes to so add her. The issue on which, and this case has been pending obviously for a long time, the issue on which we would move to add her as a party relates to this allegation that there's a wrongful mischaracterization of the loan. And this is an issue that traces back to 2011, although it was not made a part of this case until 2017. But in 2011, Dr. Shinazi had a $2 million loan to RFS Partners. That loan was recharacterized as an investment, as a capital investment, capital contribution, I guess I should say, in some point in 2011. So its recharacterization obviously changed his percentage ownership in the entity. In 2012, the parties, Ms. Eden and Dr. Shinazi, got divorced. As part of that divorce, obviously, as you can imagine, there was quite a lot of accounting and the splitting of assets and so forth. One of the things that came up out of that was this issue about the recharacterization. And Ms. Eden came back after everything had been settled and came back to the arbitrator and said, hey, wait a minute, we've got another asset. Dr. Shinazi recharacterized this loan as a capital contribution, which means that his ownership, given the increase in value in RFS Partners, is now 11% more. I want my fair share of that. And so the arbitrator, sure enough, February 9th, 2012, when we attached this to our motion. And again, this document has been floating around during this whole litigation. And it was used in Ms. Eden's deposition back in 2015. But the arbitrator said, you're right. Okay, he did recharacterize this. This did result in more money to him. So Ms. Eden, I'm going to give you your share of that money, $4.34 million.
Justin.
So that's what happened. That's where we were. As I said, it's floated around as a potential issue in the case forever. Both sides did discovery on it. We questioned Ms. Eden about it during her deposition. Mr. Frankel questioned Dr. Schnazzi about it during his deposition. He questioned his accountants about it, his bookkeepers. It was an issue that we all looked into during discovery. It was not really it was not at all a claim in this action until 2017, when Ms. Eden filed her third amended petition and asserted at that point that that was a claim that Dr. Schnazzi had personally benefited wrongfully from that recharacterization of the loan. Immediately after the third amended complaint was filed, that's when we filed for arbitration, and we went up to the Court of Appeals, and we went back, and Your Honor may recall the case was stayed for years on end while all that went on, and was not really revived until this court stepped in and said, hey, let's move this thing along in October of 2020, and got us back on track. And at that point in time, there was a motion for summary judgment pending, the court will recall, which was then subsequently denied. In May of this year, we entered into Your Honor entered the scheduling orders. And so here we are as a result of that. The statute that controls this is OCGA 91114A. And the questions, as we've set forth in our brief, in the particularly, for example, in the Voyager Life case, is whether under the factual background of the case, the third party defendant is secondarily liable in whole or in part for plaintiff's claim. And the courts have said that this is to be liberally construed for a number of reasons: avoid multiplicity of actions, save time and cost of redoing the evidence, and assure consistent results from common issues.
Let's talk about that piece for a second. So, I recognize that, there was amended complaint filed, but we're 5 years since the amended complaint and pretty much 10 years since the lawsuit. Does this, adding a party at this point, doesn't this delay things even further? Don't we have to have motion practice about whether the complaint, the third party complaint survives dismissal? Don't we have to have some more discovery on this issue? Doesn't this delay the ultimate trial of the action?
And I can answer that in several pieces, Your Honor, starting with no, and then I will elaborate. The time that this case has been pending keeps getting used against us. We're the respondent, but I'm taking into account the fact that this pops up as a result of an amended complaint, but we're now 5 years from that amendment, I believe, or 4 years from that amendment. Correct. The amendment was in November of 2017, after which point we immediately filed our motion to compel arbitration, because there were a lot of new claims raised in that we felt merited arbitration under the partnership agreement. Obviously, Mr. Franklin, his brief raises the fact that we didn't assert this claim before we filed for arbitration. Obviously, we couldn't do anything until we filed the motion to compel arbitration. We could not participate in the lawsuit. We had to file that motion for arbitration out of the gate, and we did that. And then that was litigated and not finalized until really October, when Your Honor, because of the stays and so forth, when Your Honor, reopened the case and we started back up. We didn't file the motion then, and Your Honor may recall, and I've put this in the brief, that we've raised it at every issue, at every scheduling conference, that this was on the horizon. They have known about this. There is no surprise here. Mr. Frankel had represented to the court that if his motion for summary judgment was granted, motion for partial summary judgment was granted, it would effectively end the case. So we did not file this motion back then. We could have, but we didn't, in agreement that we would wait and see what happened with the motion for summary judgment. And that's why the court's scheduling orders, the July scheduling order, the more current September scheduling order, all contemplate us adding this, because we have raised it at every point in time. We've said, hey, we've got this. We may have to file to bring in a third party if this goes forward. And in the July, it was either June or July scheduling conference, the court said, okay, understood, Mr. Frankel, what's your response? And, Mr. Frankel, everyone will recall, but he said essentially, yeah, but this summary judgment motion will resolve everything. And I said, no, it won't, because it's a motion for partial summary judgment. By definition, it won't resolve everything. And he said, it will effectively end the case. This will end the case. So we waited. So I don't think that the fact that we waited so as not to be filing things that might be unnecessary at that time should be held against us. As I say, particularly when the court's amended scheduling order, specifically the July 21st, 2021, specifically sets a deadline for us to file our motion to add parties, specifically contemplates potential amendments to the pleadings, which I will note Mr. Frankel has insisted that he be permitted to do. Right now, the second amended scheduling order, which was entered on September 28th, permits Mr. Frankel to file an amendment to the pleadings through January 30th of 2022, and then considers or allows for the court to then order briefing schedule afterwards for appropriate motions and discovery. So I think it's a little disingenuous for Ms. Eden to argue that we're trying to expand this litigation. Dr. Shinazi would like to be rid of this, honestly. But this is what he feels like he needs to do, as far as if this, now that it appears that this count is going to proceed and that we are going to proceed to a jury trial, in order to prevent having another litigation subsequent to this one between these two parties who obviously do not care for each other, it should all be handled here. And honestly, that was part of Mr. Frankel's argument for why he filed everything he filed in the third amended petition, so that we could get it all done at once. We do not want another litigation after this over this issue. It should all be done once. We should get everything with these parties together now. It's not going to expand anything because, as I said, we very well may see before the end of January an amended complaint. And considering how many have been filed before, I wouldn't be surprised by that at all. In which case, we may have to have additional discovery on that. We may have to have, there's still the opportunity, again, for Ms. Eden to file and try to add additional parties. So I don't think that what we're asking expands the proceedings at all. Let me address the discovery issue that Your Honor raised. As I said, this has been known to be an issue from day one, although we never believed it would actually be added as a count, given the fact that Ms. Eden raised the issue in the divorce and actually benefited from the recharacterization. Be that as it may, obviously, she did assert it as a count. But discovery, as I said, was conducted on this issue. The idea that we would need to have discovery over the divorce issue is, I think, a red herring. That is what it is. It's undisputed that Ms. Eden received almost $4.5 million as a result of this. Now, she can make the argument that she shouldn't have to give that back or whatever she wants to make. But it's undisputed that as an individual, what she did, and this is all in discoveries, so we don't need discovery. We don't need one bit of discovery in adding her as a party. And I would take the position that she doesn't need any discovery either, given how much she's already done with respect to Dr. Shinazi and his accountants and bookkeepers. But she learned about the recharacterization back in 2012. She raised it. She didn't object to it. She actually essentially ratified it by requesting a share of it. And she got her share of it. Those are the facts that we need for this. And then I think the jury is entitled to hear and to know that Dr. Shinazi did not keep all of this money. Dr. Shinazi paid it to her, part of it at least. And if he is in fact forced to return damages to the trust as they're asking for, that would account for the amount of the increase in his beneficial ownership as a result of this recharacterization, then he's entitled to get the amount that he had paid back. And it's as simple as that, Your Honor. We truly believe that this is the best way to avoid multiplicity of actions and to save time. I don't know what's going to happen between now and January. I don't know when we're going to get a trial. We would like to have a trial sooner rather than later. But I do not see how this issue is going to expand these proceedings when Ms. Eden is already a party in a different capacity. She has counsel. Counsel has addressed this issue thoroughly in discovery, and there are no facts beyond what's been alleged and what's come out in the depositions. It's a very simple issue. Like I said, we were surprised.
It sounds simple. It sounds simple the way it's stated, but it seems to me fairly vague, the claim for basis of relief. I looked in here for a legal basis, and all I could really find was, well, of course she has to pay it back because it's supposed to be distributed equitably according to their agreement. But I haven't seen the agreement. I have no basis. I haven't seen a proposed third-party complaint. I have no basis to evaluate whether this is even a viable claim on its face.
Your Honor, we can file that. In our research, it appeared to be not only not required, but potentially not appropriate to file a proposed third amended or a proposed complaint. We felt that we actually had to file this motion for leave before we could even file that, even as
right. You can't file it, but
No.
You can attach a proposed complaint to your motion.
We weren't certain about that, but there was some concern that we should not do that, so we did
Okay.
not. Certainly, nothing says that you have to or that you need to. And like I said, we were concerned that we shouldn't, so we didn't. We could file that at any point. Well, I would need to, but.
So what is the cause of action? What is the legal cause of action?
The legal cause of action is going to be, it's not based on the divorce or on the divorce agreement or on the divorce settlement or any of that. It's really an equitable claim. It's an unjust enrichment claim. She raised this issue. She asked for this money. She got the money. Now, in a different capacity, she's claiming it was wrongful. We claim she can't be permitted to keep the money. I mean, it's a simple common law claim. That's why I say it's not based on the contract. It's not.
So this is what I'm trying to drill down to. Isn't there a contract that governs how the money is supposed to be divided? If the contract exists, doesn't the contract set the terms?
We believe that the contract did set the terms and that is how it was done. And we are not trying to undo the contract or do anything different from the contract. But this is a different issue because now Ms. Eden, in a different capacity, is coming back and trying to say, hey, you got this money wrongfully. You shouldn't have this money. When in fact, the truth of the matter is she has part of that money because she asked for part of that money and she got part of that money. So we're not basing this on anything that happened in the divorce or what the divorce decree said or the settlement agreement or the arbitrator's agreement or whatever. We're basing this on the fact that as an equitable matter, Ms. Eden cannot retain that money when she acquiesced in the accounting procedures, claimed that money was part of their, not only was owned by Dr. Shinazi, but was part of their marital estate, and then claimed her fair share of that money. She received a portion of that. It violates equity for her to now come back, albeit in a different capacity, and say, oh, you got that wrongfully. You shouldn't have that. You should have to pay all that money to the trust. when in fact, she got part of that money because she raised the issue and she said it was owned by Dr. Shinazi and she said she was entitled to part of it. So
Is Ms. Eden as trustee operating under a conflict of interest?
Well, I think so, but that's another issue as well. That's why I thought the claim would never be raised, honestly, Your Honor, but it was. So that's where we are. And that's our position. I do want to address also the timeliness of the motion. And I know that this was just.
I'll tell you, you don't have to address that because how I rule on this is not going to be based on a timeliness issue.
Okay.
I'm more concerned with the efficiency by which we can handle these claims and whether there is in fact a substantive viable claim to take up our time with. Those are my issues. I think with the pandemic, the appeals, the issues with mediation, maybe Mr. Frankel can convince me differently, but as where I sit right now, that's not an issue that you have to convince me about. Mr. Frankel will have to unconvince me on the timeliness issue.
Understood, Your Honor. Then I will leave that be.
All right. Anything else?
No, Your Honor, unless there's another issue you'd like me to address at this point.
All right. I'll turn to you, Mr. Frankel.
Your Honor, I'll just jump in kind of on your first question and your second, which really were the same question. So is there a cause of action that you could implead under 9/11/14? The simple answer is no. So under 9/11/14, you're talking about either derivative or secondary liability relating to the underlying claim. It's going to be contribution, it's going to be indemnity, but it's based on the underlying claim. The underlying claim here is for breach of fiduciary duties and recharacterizing a loan to a capital event, and is doing so giving himself approximately 5% more ownership than he previously had. So what is going to be the remedy? If we prevail on that breach of fiduciary duties claim, the trust is going to own 5% more than it currently does on paper. It's going to change the ownership of the trust, which I understand today is worth about $200+ million. So it's not an insignificant dollar change. The claim against Ms. Eden personally, and I appreciate Ms. Wade being clear, it is in a different capacity, and therefore she is in fact a different party for purposes of that. That claim is in fact based on the divorce decree. The obligation for Dr. Shinazi to pay any money was based on a provision in the divorce decree. The divorce decree was a negotiated document. I was not counsel. I don't do divorces, but I have seen the file and seen the decree because it was relevant. And as I understand it, it was based on a very complicated but very incomplete presentation of assets by both parties. And so as part of the settlement agreement, because there was huge fear, legitimate or otherwise, that Dr. Shinazi was hiding assets. He was the one in the marriage who controlled the majority of assets. So as part of the compromise in the settlement, and that was of course enforced with a decree, that incorporated by reference the settlement agreement, it was said if within a certain period of time, additional assets that were not disclosed in the attached pages and pages and pages of assets are found, then an arbitrator could decide to shift it. The arbitrator had and get a reimbursement to affect what was going to happen in the divorce. Now, how it was divided was based on the divorce decree. It wasn't she got 100 cents on the dollar, nor was it determined how you're going to figure out the value of the asset. None of that was determined for purposes in the divorce decree. And nor do we know what in fact Ms. Eden got back or didn't get back. She didn't get ownership. They didn't split the 5% ownership. The ownership stayed as far as the trust was concerned, as far as Ms. Eden personally was concerned. The ownership interest in the partnership stayed the same. The ownership of the trust stayed the same. But because Dr. Shinazi had failed to disclose an asset under the terms of the divorce decree, she was entitled to get paid, and it was determined by an arbitrator. What's key here is there's also a release. So there was a very limited remedy for breach of that contract. And one of the breaches was you failed to disclose an asset that you owned in your own name. That was Dr. Shinazi's breach. And because of that, an arbitrator had to figure out what would happen under the terms of the settlement decree, the divorce settlement. The divorce settlement did not see if it's later determined that somebody else, a trustee, an individual person, owes money or has a cause of action, then Ms. Eden or Dr. Shinazi would have to pay it back. There is no subsequent remedy, but there is a full release that says, except as provided in this agreement. And remember, the carve out for additional assets was found. Except for what's in this agreement, you release all claims arising out of the marriage. Any entitlement to a reimbursement is going to be a claim arising out of the marriage. Now, a claim for reimbursement can be based on many things, but Georgia law is pretty clear. Equity will not come in when there is a contract, because the contract is enforceable. And this contract addresses those terms. If we go forward, so not only is there not a cause of action, because the cause of action has to be the same one, breach of fiduciary duty. And that gave the secondary liability, the derivative liability to the individual for contribution. There is no identity of a cause of action. There's no such thing. To the extent there's going to be any entitlement is because Ms. Eden got something under a contract that is a similar damages, arguably, to what somebody else could have gotten in a breach of fiduciary duties. But the breach of fiduciary duties is going to result in a change in ownership, not in a monetary award. And we have no idea how the arbitrator came up with that dollar value of that amount. We would need to seek discovery on that. Did he use a discount factor because Dr. Shinazi was a minority owner? Did he give less of a control factor for the discount because Dr. Shinazi was the controlling partner? Did he look at, and I have no idea whether he did, whether or not Dr. Shinazi had complied with the partnership agreement when he did that? That's kind of important because the underlying lawsuit, the original lawsuit that was filed, found, in fact, that Dr. Shinazi had violated the terms of the agreement by doing that when he gave the original amounts to himself, when he did the loans. So our argument here, of course, is he did the same thing, and frankly, it'll be law of the case. We don't know what he considered, nor do we know, did she get 50%, 40%, 30%, 20% of what? These are the questions you would have to ask. They're all different. But the fundamental question you're going to have to answer initially is, did Ms. Eden breach the contract? Does the contract provide a remedy? All those issues have nothing to do with this lawsuit, nothing. So I think for those reasons alone, frankly, because she has not complied with 911-14, it's not a derivative or secondary liability. And because the claim, if you proceeded, is going to be for breach of the divorce agreement. Whether you call it unjust enrichment, whether you call it equity, it's for breach of the underlying agreement for different remedies. And that is a wholly different claim. And no, it doesn't smooth things over and make this an easier trial, and only expands it. I do want to mention something, and there is discovery that we would need to see, but I do want to mention something about the timing, although I say with a smile, I'm not sure it changes things. This case really has gone on a long time. The case was originally filed, I believe, in September or October of 2012. And for reasons that don't matter, discovery was delayed. But the issue of this recharacterization of the loan was in the original complaint, in the breach of fiduciary duties count. That is why it was addressed in discovery, and that's why it was by both sides. And so, yes, Ms. Wade is correct. It was known in 2015. So at that point, frankly, if they had decided at that point strategically to seek to add Ms. Eden, they could have. But what happened after that? We went ahead on cross motions either to dismiss or for summary judgment. And although it took the court some time and it was a complicated issue, everything was stayed essentially while we waited for the order. And the order ultimately came down that summary judgment was granted. Then it was appealed and cert was applied for. And that took a while. But ultimately in 2017, I can't recall whether it was June or July, But in 2017 is when the remitter came back to the court. And that is when we realized there was a change in what the court had said. The court granted our summary judgment on the merits of the loan issue, having a substitution of a loan in exchange for the stock. We prevailed, but the court had previously ruled against us on the breach of fiduciary duties claim and said that was precluded. The appellate court said, no, you can go forward. And at that point, we evaluated in 2017, would it be helpful to the court to clarify? And that is frankly what led up to our other summary judgment. So we took the breach of fiduciary duties count and broke it down to be clear. One of the issues was the issue that Your Honor already ruled on our summary judgment. That was the issue of whether you had to pay a distribution or whether you could return it. That was already in the lawsuit as well. But we took it out to be clear. And so frankly, we could have an issue upon which to seek summary judgment. We did the same thing with this claim. It was always there. We broke it out in count two to be clear. We did it for several reasons. One was we really wanted to be clear. But two, when you go to a jury, clarity is really important to understand what you're breaking down. And at this point, the only thing we were going to a jury if we proceeded was the breach of fiduciary duties claim. So we thought it would be helpful to the jury. That is what happened in 2017. Your Honor's aware of it. There was a delay. They sought arbitration. There was an appeal. The appeal came back. They was denied in or around January of 2020. And then for reasons that I'm not quite clear, it was Ms. Wade's position that discovery was stayed and we didn't have to even address the summary judgment motion. So no motion to add a party or anything else was added then either. Ultimately, the stay was lifted affirmatively by you. That was in October of 2020. And yes, this issue has always been extant. And it wasn't until July of 2021 that it was raised. We had had several case management orders, obviously negotiated between parties and presented to Your Honor. But this is almost at the end of discovery. It's really, and we were having a case, it really is at the last minute. If this was something that needed to be raised, and it was something that was raised in 2017, but for procedural reasons, there couldn't be an amendment in 2017, there could have been one in 2020, anytime in 2020. Your Honor is right, by the way, that as a general rule, you attach the complaint, the proposed third-party complaint to your motion to add. But Ms. Wade is also right, though I was surprised, not that she's right, but I was surprised by the answer. It's not required. In federal court, it may be required, but not in state court. For whatever reasons, it's just a fluke. But I think it is required in federal court. That is the preferred procedure, but she is right, it is not required. So failure to do so doesn't have any preclusive effect whatsoever, but it does show the difficulty in understanding the cause of action. So we are sitting here a long time. We do have the right to amend, but Your Honor, that was really put in there based on one, you always leave it in there, but based on discovery we were going to obtain on the underlying issue, which I think we finally got, although there are some gaps there. But that really was its purpose. I don't have any plans on amending other than perhaps withdrawing claims and trying to clean things up. But that is going to be normal in a case management order where you have the opportunity to add claims or anything else. So I leave with, this is interesting, but Ms. Eden is not the trustee. She is a different person. It's an individual claim against her. It does not arise out of, it's not secondary, and it's not derivative, and it would expand the litigation at this late stage. And it would really talk about an evaluation of a divorce information, none of which we know about.
Is your client ready for trial?
I think we are. We just got the financial information that relates really to how, whether there was an issue that you identified in summary judgment, which was there's a fact issue as to whether the contribution was returned, and we have gotten financial information. We've just started to go through it. There was some delays for whatever reasons, and we are still missing things. For example, we don't have tax returns or financial statements, but we're trying to see if there's a contribution. So far, our numbers show that there's different, but obviously that's a jury question. So once we've gone through the financial information, I do believe we would be ready for trial.
So I understand the position that it's not appropriate to file a third-party complaint in the context of this case. But it seems to me that there's going to be further litigation either way. Would you agree with
Well,
that?
it will depend on the result in this case, Your Honor.
Right, it depends on the result.
And the
of
answer
this
is
case
there might be, it would be again between different parties. Interestingly, and we bounced this out around at our firm and with Mr. Cloud, the similarity, and again, I give Ms. Wade credit, is really the similarity of arguing over damages. Different causes of action, different parties, but you might in fact have an issue of, what's the right number if and when that ever happens. And I don't have an answer to that except to say what happens here would have an effect, but you'd still have to understand what was the basis in the divorce. And even then, that's actually getting to the damages question. It's not getting to the liability question.
What's your reaction to allowing the third party complaint to be filed, but staying it until after the main issues are tried that are ready for trial? What's your reaction to that?
I actually thought about that, although perhaps not as much as I should have. My immediate reaction is no. And it's no for several reasons. One is that's not what my client wants, and I do not represent her in her individual capacity. And I don't think I'm in a position to be making any decisions on her individual behalf. Secondarily, with respect, I think that's outside your discretion. It does seem to be a good way to organize things. And you are a court of equity. But I don't think when we're talking about allowing a third party to be impleaded in a third party complaint, I think we have to comply with 9/11/14. And I don't think it happens. But I think the real practical answer is, how does it change anything? If in fact, we're going to stay it until after this ruling, and I'm going to assume, unless the parties can reach an agreement, and it is a side, Your Honor, we're trying, I'm going to assume that the losing party is going to appeal things. So we're going to get our third appeal forever. It's going to take a while. All that's going to be stayed, but presumably the day the remitter comes back, whoever is unhappy or whatever is the position could file that lawsuit that day. It's not any different than staying it. So I appreciate the practical approach, but for those reasons, I politely say no.
And when you say, and you say that when you say it wouldn't be appropriate to bring it in and state it's because it's not in accordance with 9/11/14.
Yes, Your Honor.
But not a different reason.
I don't know whether the answer, I haven't thought it through. When you bring a lawsuit that is not an impleader in a third party, but instead a separate lawsuit in the same one, now I think we're talking about 9/11/13. And essentially you're suggesting, if I'm hearing you right, essentially a consolidation of cases. If I heard that right, and then staying it, and under that circumstance, you actually need our consent. A court does not have authority to consolidate cases. They could assign them to the same judge. And frankly, I think it would if it went forward. But I think to take an unrelated claim not under 9/11/14 would in fact be adding a party or adding a new claim. I said 9/11/13, it may be 9/11/16, I forget. But the bottom line is, I don't think you can do that to have unrelated claims against different parties. I think you would need our consent, but I have not researched that. That's my memory.
All right. Thank you, Mr. Frankel. Ms. Wade, you get the last word.
Thank you, Your Honor. First of all, just again, to pick up on what you were just talking about, 9/11/14 is so broad. It's almost shockingly broad, and it is almost shockingly liberally construed. I mean, when I went to go do the research and find out, okay, what are the parameters? What do the claims have to be? What did this, there aren't any. The case law is very clear that it is to be very liberally construed. The court has immense discretion and is supposed to look at the facts and is supposed to look at this on, like I said, I mean, the basis of those issues about multiplicity of actions, about judicial conservation of resources, and assuring consistent results. And so that is really what the court's supposed to look at. The issue about the divorce, again, this is not a breach of contract claim. It would not be a breach of contract claim. There's no way in which I can see at this moment, at least, that Dr. Shinazi could contend that Ms. Eden has breached their divorce settlement agreement. But by raising this issue, by alleging that Dr. Shinazi has breached a fiduciary duty to the trust, Ms. Eden has created a whole new issue. This isn't about equitable division. This is about what she's claiming he wrongfully did and her part in it. It was apparently, according to her, a marital asset. So they both owned it. They both had the obligations. They both had the duties. If he breached the duty, she breached the duty. I mean, this really falls under what Ms. Eden has raised as a claim in this case. It's not a breach of contract claim. It's not anything to do with the divorce action. And I can answer a lot of Mr. Frankel's questions just by looking at attachment A to our motion, in which the arbitrator made it very clear exactly what he did and exactly why he did it. He says very clearly, and I just want to raise this given all of the questions Mr. Frankel has raised, that the arbitrator finds that this addition is subject to the equitable division provision of the memorandum and agreement. A division in kind would, in the opinion of the arbitrator, create future problems for the parties. Boy, if he only knew. A division not in kind will be simpler and can take into account a liquidity and or tax discount. Therefore, Dr. Shinazi should pay to Mrs. Shinazi the amount of $4,340,533.20, paren, $5,425,666.50, less 20% to comply with the equal division provision. He makes it very clear exactly what percentage he applied. That percentage was applied for the discounts, which I guess is they used I guess they used the same type of discount throughout. I don't know. But again, it's right there in black and white, exactly what he did, exactly how much she got, exactly what discount was applied. That's all right there, black and white. During Ms. Eden's deposition, just to go back to the timing issue, back in 2015, we were trying to figure out if this was part of the claim, right? And I specifically asked her, and this is referenced in the brief and is in her testimony, which is in the record, whether she contended as part of this litigation that the recharacterization of that $2 million loan somehow damaged the trust. She said, I can't answer that question. I don't have an opinion about, I don't know. And that's what we got all through, was nothing specific. And, you know, I think Mr. Frankel was trying to keep his options open, which I respect. But it was not clear at all that this was an actual count being asserted in the litigation. I also asked her during her deposition if she had thought about the fact that if this was raised as a specific claim in the case, that she would likely need to be brought in individually because she had received a portion of that money. She said, well, I haven't really thought about that. So the delay issue, I think, is just, it's not, there's not a delay. This was not formally a part of the case. We couldn't ascertain whether they were actually trying to assert it or not. Everyone used throughout the case until the Third Amendment complaint was filed. And even after that, the parties all used the same percentages that the trust owned, the 72 point, I'm getting the percentage wrong, whatever the percentage is. If only they had done it so that it was like an even number, it would have been really helpful for us. But that percentage, and nobody questions that. So I also would point out that with respect to the damages issue and Mr. Frankel's claim that the remedy would be a transfer of a portion of the percentage of the trust, I don't agree with that at all. I think that the remedy would be, and of course we haven't really explored this because no litigating has actually been done on the Third Amendment complaint again, but still, to just speaking off the top of my head, I was surprised when he said that, although I shouldn't be, given the value, and that would obviously increase the damages. But I think that the damages, if there were any, would potentially be a portion of the increase in value to Dr. Shinazi at the time of the recharacterization or something like that. Your Honor, I'm sorry, I've just received a notice that my computer is about to shut down. If you, would you bear
Yes,
with
we'll
me
give you a
one
moment.
second? I must be unplugged, although
Again,
I am plugged in, but hold on. Ah. Okay, I'm sorry about that. I just had to climb behind my desk. Looks like someone had borrowed my outlet for something. Hey, I just got the little red, your computer's about to shut down. I thought I was making a really good argument. In any event, I think that it would be the again, and I'm literally thinking through this right now, but I think the damages would have to be calculated as of the date of that transfer. It's very difficult, but I'll put it this way. I don't think that there is certainly no agreement on this side that the remedy would be a transfer of some percentage of ownership of the limited partnership. So I think that the fact that it's a damages issue, I mean, that is what bringing in a third party is, right? I mean, that's the whole point, is you're saying she's liable for part of these damages. And that's what 9/11/14 talks about. Again, we really would like to just get all of this resolved in one action. Whether it's bringing it in and staying it, I don't know. That might be a viable alternative. I don't know. And I also don't know if anything else is going to be pursued. As Mr. Frankel said, he's just received the documents. There are a lot of them. I don't know if they're planning to file something else, but that's all I have, Your Honor, unless you have any questions. So we think that it actually does promote judicial efficiency to try to get this all into one case, and that it actually absolutely is appropriate under 9/11/14.
Your Honor, might I just mentioned there's two cases we cited in our brief that actually say the opposite, that it actually has to be secondary, and if not, it has to be dismissed. And the underlying causes of actions aren't the same. The reason Ms. Eden was able to obtain additional funds under the divorce decree was because of Dr. Shinazi's breach of the divorce decree. It wasn't a breach of his fiduciary duties. And there was no analysis that I'm aware of as to whether the transfer was or wasn't legitimate at the time, because the only issue was he didn't list it on the asset list. And then he filed a tax return where it was listed. That's how they found out.
all right. I think I've heard enough on this. It's a difficult issue because clearly these cases are related, and clearly there's an argument to be made that to the extent the money flows back from Mr. Shinazi, he may or may not have some claim for reimbursement for part of that. I'm not sure what the legal theory would be, but there are clearly common issues of fact in these two cases. But it doesn't fit in with when I read all the cases about leave to file a third-party complaint, it doesn't fit in with those lines of cases where they all arise out of ultimately the same cause of action or the same event. It just doesn't quite fit. And looking primarily, as I look at it, for economy and efficiency, it makes sense, certainly from an efficiency standpoint, for me to hear that claim and ultimately get a ruling, but it's not efficient for this lawsuit and everything that we have done so far in this lawsuit. I think if I add this claim, it's going to divide our attention among the claims that have already been fully litigated and new claims that still have to be fully litigated and possibly on appeal. And I'm hearing theories that about equity, and I'm hearing divorce decrees, and is it contractual? Is it not contractual? What's the measure of damages? It seems like there's going to have to be a lot of legal vetting to do with these new claims, all of which would further delay the main claims that I think are ready or very nearly ready for trial. Those claims should happen and should be tried without the distraction of these other claims. I think that, perhaps if we had dealt with these claims from the beginning, and this is not really a unnecessarily delayed claim, but I think it's more of a strategic issue. If we had been dealing with all those issues and been able to handle those issues in summary judgment along with the other issues, I think it might have made more sense early on, but it doesn't make sense now. The motion for leave to file a third-party complaint is denied. I certainly think y'all should talk. I know you're talking about other issues, but you should talk about, what it makes sense, how it best makes sense for all parties to deal with those issues. I think it makes sense for y'all to deal with those issues with me, but I think it only makes sense to deal with those issues if we need to after we've resolved this main case. So the motion is denied. Mr. Frankel, if you would prepare an order and send it to Mr. Townsend, run it by Ms. Wade first, make sure that she has a chance to sign off as to form only, not as to substance.
I will do so, Your Honor, unless you instruct me otherwise, I would make it a very short and sweet because there's no need.
I think that is correct. Do we need to do anything with scheduling? Well, we have everybody here. It sounds like there's some cleanup discovery that still needs to be had.
And Your Honor, in fairness to Ms. Wade, she had asked for more time. Her client is involved in other things. She gave us a lot of documents. I do think there are some missing. I'll try to bring that up with her, and hopefully we can resolve that among ourselves. This is not a lawyer issue.
All right,
Yeah.
and is there? I'm sorry, Ms. Wade.
I'm sorry, Your Honor. If I might, I was just going to respond to Craig and say it would be helpful probably if we would discuss that offline, because I gave them.
That's what I mean. That's what I'm saying.
Everything I can scrape up. I mean, it was over, in Mr. Frankel's defense in reviewing it, it's over 5,000 pages of documents. You don't just hand over an accounting for a $200 million partnership without a lot of pages. So there's a lot of pages. So, but I believe it's all there.
All right, do we have, so is it safe to say that discovery is going to be complete?
I think that we have the right to do some follow-up cleanup discovery on December 1st, is my memory. And
I do not remember.
But to the extent that we do, it's going to be on the narrow issue of the financial stuff.
All right, so are we in position to try, think we'll be in position to try this case first half of next year?
I believe so, Your Honor. The only issue that would be extant that I don't think I have given the thought to, or maybe Ms. Wade is not, is the expert issue. I know that's in the case management order as well, that we can designate and cross-designate experts. I'm not sure we're there yet and thought about it. That gets to the damages issue, I think, primarily.
Right.
But I will acknowledge that I have not thought that through. I was waiting to see the financial documents.
All right. Any other matters that we can discuss while we have everybody on?
I don't
All
think so,
right.
Your Honor. Nothing from respondents.
I don't think so.
All
Your Honor.
right. Thank you, everyone.
Thank you, Your Honor.
Thank
Thank
you as
you, Your
always
Honor.
for your time, Your Honor.
Thank you, everyone. Happy holidays to everyone.
Happy
Thank you.
holidays.
Happy Thanksgiving.
Bye-bye.